The law of contracts with Lord Jenny. Mention of an offer. Alright, so last time we perused through the course outline of the law of contract. So today we'll dive right into it and discuss a few principles, introductory principles of the law of contract. So the first topic in your course outline is the formation of a contract. So here we're going to look at the means or what is needed, requirements that are needed in order for a contract to be successfully formed or completed. So basically, we have four requirements, or sorry, five orders that have to be first met in order for a contract to be successfully formed, which is an offer. There must be an offer. Second, there must be an acceptance. Somebody has to accept your offer. Thirdly, there must be consideration. Both parties have to provide consideration. Of course, we'll learn more about this as we go on. Then the fourth one, there must be intention to create legal relations from both parties. Fifth, there must be capacity. The parties that enter into the contract must be of full capacity. Don't worry, we'll discuss or we'll talk about what this means in details as we go on. So now we'll talk about an offer. However, before we talk about an offer, we first want to acquaint ourselves to what a contract is. We have to know what is a contract. What does a contract look like? Of course. So a contract is simply an agreement by two parties that they promise to be bound on specific terms. So a contract can be either written or oral, as long as there is an agreement between two parties to be bound by specific terms. I'll have to give examples because it makes understanding easier. So, an example is this. Let's say Mr. Banda goes to Mr. Piri, saying, Mr. Piri, I love your car. I want to buy your car at 200,000. Then Mr. Piri says, all right, you can have my car, 200,000. Give me the money and the car is all yours. Then Mr. Panda gives Mr. Piri 200,000 in cash and gets the car. Then therefore, that is a contract. It can be either written or orally. As long as there is an agreement between two parties to be bound on specific terms, then the contract is therefore completed. So we now look at the requirements that are needed because there's some things that first have to be met in order for a contract to be completed. So, just as we discussed earlier, an offer. We'll start with an offer. So, what is an offer? An offer is simply an expression of willingness to contract on specific terms. So, this is more like one manifesting their intentions to bind on specific terms. So, according to the example that we just gave about Mr. Banda and Mr. Piri. So, the moment Mr. Banda went to Mr. Piri saying, I want to buy your car at 200,000, that in itself was an offer because Mr. Banda expressed his willingness to purchase the car. So an offer has many definitions. So you can go by you can also you can also make your own definition as long as you fit the right words. But for starters, an offer is simply an expression of willingness to contract based on specific terms. So if one comes to you expressing his intention to purchase something or do something, then that is simply making you an offer saying, here, I understand this is your pen and I want to buy this pen at 2%. That in itself is simply an offer. And that is the first requirement for a contract or the first step. There must be an offer. So there are several cases that you must look at in order to understand what an offer is in detail, or because these cases are simply discussed what an offer or the scope of an offer is. Among many cases, we have the case of Rating Valuation Consortium versus Lusaka City Council. This is a very anticipated or very important case because it touches on various and many principles of contract law. It was a case that involved a rating valuation company versus the council of Lusaka. So an offer was discussed there, the scope, what an offer can be and what cannot amount to an offer. So I highly advise that you read the case in full. It's a very long case, but I advise you to read that case in full. Therefore, while talking about an offer, it is important to make mention of a principle known as invitation to treat. An offer, it must be mentioned. I emphasize this. An offer must be always distinguished from an invitation to treat. So, like we discussed, an offer is simply an expression of willingness to contract or an offer made by one party to another. Yes. While an invitation to treat is simply an invitation to receive offers. This is very important to note. An offer is simply an offer made or is an offer made by one party to another. While an invitation to treat is simply an invitation or an offer or an invitation to another party to receive offers. So, by using the example of Mr. Panda and Piri, here's an example. Let's say Mr. Piri, an owner of the car, goes to Mr. Panda saying, Mr. Panda, I have a car. It's a brand new car. I want to sell it to you. How much can you give me? So that is not an offer. That is an invitation to treat. Mr. Pili is telling Mr. Panda that he has a car and he's willing to sell the car to Mr. Panda. So if Mr. Panda is interested in the car, he now makes an offer saying, okay, I have heard it. I will buy your car at this amount. So Mr. Piri, the owner of the car, was simply inviting Mr. Panda to make him an offer. Yes. So there's a thin line between an offer and invitation to treat, but it's really, really cardinal to take note of the difference. So we have examples to fully enlighten our understanding on an invitation to treat. There are examples of an invitation to treat. This will guide us in order to understand what an invitation to treat is. And we also look at several cases that demonstrate what an invitation to treat is. So we have an auction. So auctions are typically invitations to treat. These are not offers. I'm sure by now you are aware of, you're familiar with the term auction. So an auction, this is where various parties are invited to an event or one place where the auctioneer puts an object or an item turn by turn, and the people in the audience who are interested in that object will bid. Then the highest bidder or the person with the highest amount of money will obtain that property or item that has been displayed. So an auction, in its sense, where the auctioneer puts an object, saying, for example, what object can one take to an auction? Or for example, a blanket. Yeah, a blanket that is worth 20,000. Then it goes to an auction, then takes it to an auction. Then the auctioneer there stands up and says, the first item is this blanket. So that in itself is not, the auctioneer is not offering you the blanket. No. The auctioneer is simply telling you or inviting you to make offers for the blanket. So if you respond to that saying, okay, I'll get that blanket at 10,000, then the other one says 12,000. So those two have made offers. Then the auctioneer is at liberty to accept any offer there. So you now get in the sense the difference between an offer and invitation to trade, because the auctioneer simply invites you to make an offer for that object. Then if he is satisfied with the offer you have made, then he may accept your offer. So there are several cases that you can look at in terms of dealing, in terms when we are talking about auctions. So so the several cases just like I have said. So we have the case of Nicholson versus Harris. We also have the case of Payne versus Kev and several others. You are advised to read several cases. So the few facts or the few details of the case of Nicholson versus Harris was this: the defendant, Mr. Harris, invited Mr. Nicholson to an auction. So he told Mr. Nicholson that I am hosting an auction and you are invited to come to an auction and purchase the furniture that you may wish. So that auction was designed to sell all furniture such as tables, chairs, and the like. So Mr. Nicholson went to the place where it was believed that the auction would take place. However, Mr. Harris forgot to inform Mr. Nicholson that the auction had been cancelled. So Mr. Nicholson went to the auction place and found nobody. So he decided to take the defendant, Mr. Harris, to court, saying, Mr. Harris gave me an offer to attend his auction, and I accepted the offer, hence completing a contract. So Mr. Harris had breached his contract because he invited me to an auction. I went there, but there was no auction. So that means he's the one to blame. He should pay me for the transport and everything. So what Mr. Harris claimed, the defendant, was no, an invitation to an auction is not an offer. It's me inviting you to come to an auction so you can make me offers. So the question for the court there was to answer, or was to discuss or expound on the thought: was an auction an offer or an invitation to treat, or and was an invitation to an auction an offer or an invitation to treat? So if it was an offer, if Mr. Harris made Mr. Nicholson an offer by telling him to come to an auction, then indeed Mr. Harrison had breached his contract because there was an acceptance if it was so. But if, however, it was an invitation to treat, then there was no breach of the contract. So the court had concluded that Mr. Harris' invitation to Mr. Nicholson to attend an auction was not an offer, but an invitation to treat. He simply invited the plaintiff, Mr. Nicholson, to attend an auction so as to give him and so as to make offers. So an auction is not an offer, but an invitation to treat. Neither is an invitation to an auction. So that is the case of Nicholson versus Harris. You are advised to read the case in full. Then we have the case of Payne versus Kev. Well, this case brings an important principle, and I would love to leave a question for the audience today, so that next time we'll come and answer the question that was raised in this case. The details of this case will be discussed in the next video. But the question that I would love to leave is this: if an auctioneer puts up an object, then one in the audience raises a bid for the object, then the auctioneer accepts his bid. He says he brings out a blanket, then the man in an audience says 2,000. Then the auctioneer accepts the bid. Then before he brings down his hammer, the man in the audience decides to withdraw his bid, saying, no, I made a mistake. I do not want to get that blanket. Can that be deemed as unacceptable? Or was the contract already formed when the auctioneer accepted his bid but didn't bring down the hammer? Or will the contract be formed once the auctioneer brings down the hammer? So the basic question is, at what point does a contract at an auction get completed? At the time when the auctioneer brings down the hammer, or at the time when the auctioneer orally accepts a bid? See you next time.